Trump is finally taking the fight directly to the United States Supreme Court in Pennsylvania. This time he's challenging lower decisions of the Pennsylvania Supreme Court over Pennsylvania's election laws. Trump is still fighting for the presidency even now on December 22nd. This document was filed on December 20th, and he is asking the Supreme Court of the United States to intervene in Pennsylvania and to invalidate the election results, a similar request to what we've seen before, only this time further fleshing out the constitutional issues raised by the Pennsylvania Supreme Court decisions, which apparently, according to the document here, violate the Article 2 Elections and Electors Clause of the federal Constitution. So to clarify, they're saying that the Pennsylvania Supreme Court's decisions upholding various things and allowing the election results to go on have impacted and implicated the federal Constitution. And they've raised three very important and as of yet unanswered questions to the United States Supreme Court, and we're going to take a look at those. This entire document is 250 pages. The petition itself is about 32 pages, so we're not going to go through all of it because it would take all day, but we are going to hit the main three questions as this is just a quick update, and I'll try and provide a brief explanation of why each of those questions is important, but I'll say it in sort of non-legal language. The first one, whether the Supreme Court's alteration or suspension of state election law through its three decisions before and after the November 2020 general election usurped the Pennsylvania legislature's plenary authority to direct the manner for appointing electors for president and vice president in violation of Article 2, Section 1, Clause 2 of the U.S. Constitution. Okay, let me translate that into normal people talk. The Pennsylvania legislature, under the federal Constitution, has plenary or sole authority to direct the manner for appointing the electors for president and vice president. That means they're the only group that gets to do it. That's what the federal Constitution says. It says each state's legislature shall direct the manner for picking its electors. All right, so what their argument here is that the Pennsylvania Supreme Court changed the law passed by the Pennsylvania legislature, that it meaningfully modified the law through its decisions, and therefore that took over the power by the Pennsylvania legislature. So a very important question that has gone on not only in Pennsylvania, but also in other states, not necessarily through the Supreme Court, but through executive actions or administrative actions in those states, as we saw in Georgia, as we saw in Wisconsin, and as we saw in Michigan as well. Okay, question 2. Whether the Pennsylvania Supreme Court's three decisions usurping the Pennsylvania legislature's plenary authority to direct the manner for appointing presidential electors by changing the law, including eviscerating protections against mail ballot fraud, violated the Due Process Clause of the Constitution, and whether Pennsylvania applying the new rules promulgated by the court during the election in only select counties where mail ballots were heavily favored one candidate over the other violated the Equal Protection Clause of the Constitution. So this question is actually a two-part question, and that is assuming the first question is answered yes by the court, that the Supreme Court did usurp the authority of the legislature. So if they did, they have to ask whether or not they did it through the due process or through a due process violation or a violation of equal protection. The Due Process Clause says that basically you have due process to your legal remedy. And everybody attacking Trump for challenging the election through the courts, look, he has a due process right enshrined in the Constitution, the same as you or I under the 5th and 14th Amendments. We have a due process right to the equal protection of laws. We have a due process right to the application of our laws. And that is what Trump is arguing here, that by doing this, they violated his right to due process or right to a fair process under the law. That's the first part. The second part, the Equal Protection Clause, says that county to county in the state, there were different sets of rules. Now, the lower courts have uniformly said that this is not actually what equal protection means, although a common sense understanding would say that two different rules in the same state in different counties that have different voting proclivities would be a violation of what equal protection is. So that's the argument there that they're going for. The lower courts have almost entirely said that this is not equal protection. However, the Supreme Court has, in the past, in Bush v. Gore, indicated that different rules amongst different counties can be a violation of equal protection, although that is a very different question than what's raised here. Number 3, whether this court has the power to provide a meaningful remedy to petitioner in advance of the January 6, 2021 joint session of Congress, at which electoral votes will be opened and counted, or before the January 20, 2021 inauguration date specified by the Constitution. So this is an important question that has to be answered by the court and has to be argued very, very well. And this is probably the murkiest question of all. We're now past the date when electors have cast their vote. That date is a date implemented by the federal Congress. It is not specifically in the Constitution, but it is granted under authority of the federal Congress that is in the Constitution. So the question is, can the Supreme Court provide any remedy after the electors have already cast their votes, but prior to either the reading and counting of the votes or the inauguration date that is in the Constitution? If the Supreme Court even has power to intervene here. Trump is asking that very, very important question, again, for which there isn't really an answer. This hasn't been tested in this way before, so they're asking a novel question to the court. All right, that's a summary of what's going on. Again, Trump is still fighting. He's still trying to win in this election. What is likely to happen? Well, if history is repeating itself, the court will probably just ignore this. We'll say that the president doesn't have standing. Although, again, if he doesn't, who does? Well, if they don't use a standing argument, may use something like latches or some other argument that this case is moot and is that the court no longer has power. Unfortunately, question 3 really leaves the Supreme Court with a very flexible decision to say, no, the Supreme Court does not have the power to provide a meaningful remedy after the votes are cast and before the votes are counted. However, that would still be a very important decision for them to render, because we would know the official Supreme Court deadline for action on election issues. And that may be the way out that the Supreme Court takes. It would be an easy one for them to take, and it would set up a precedent going into the future. But will they even take this case is another question. They don't have to grant this petition. They don't have to hear the case at all. And if there's any likelihood that you can predict, it will probably be that they'll ignore the questions entirely and deny cert in this case. So that is what is going on. That is how Trump is still fighting in the Supreme Court. Hope you found this informative. Please like, subscribe, and share. Thanks a bunch. Have a good one. Peace.